Emily wrote this report, and by the way, after she talks, we hope to have a dialogue with you in the audience. Emily wrote this report at the Brennan Center. Before she came to the Brennan Center, she was president of the NYU Law Review, and then clerked for the chief judge of the Second Circuit. So Emily, with those encomiums, you jump in here.
All right. Well, I won't claim to be the expert on executive privilege in the room, but I probably am the expert on what's actually in the report. So that's what I'm going to talk about. Can everyone hear me without the microphone? You want the microphone? All right. Thank you. So as you've heard, there's general consensus that secrecy is a longstanding problem within the executive branch, and executive privilege is a very powerful tool in that secrecy regime. And in looking at this issue at the Brennan Center, we concluded that executive privilege as it currently works is broken. And anyone who followed the congressional attempts to get to the bottom of the controversial firings of the U.S. attorneys in late 2006, which that effort was effectively thwarted by claims of executive privilege for months and months. That case alone illustrated to us that Congress struggles to enforce even legitimate subpoenas for information that it vitally needs. And so what we've come up with is a piece of proposed legislation which we think could create a framework to better resolve executive privilege disputes when they do arise. And the proposed statute offers a comprehensive framework that has three essential elements to it. The first is that it provides guidelines to the executive branch about when it would be appropriate to claim executive privilege in cases where the president is confiding with his close advisors, certain diplomatic information, certain law enforcement information, all could be covered by the privilege. Notably, it does not recognize state secrets as a valid basis to withhold information from Congress. That's something that we might discuss in the Q&A if people wonder about that. The second aspect of the statute is that it then sets out what Congress must show in order to overcome the privilege, because as the U.S. versus Nixon case established, executive privilege is a qualified privilege, not an absolute privilege, and so even when the information is privileged, a sufficient showing of need for the information, it has to be disclosed. So under the statute, in the case of presidential communications or diplomatic information, if Congress is able to show a specific need for the information in order to carry out its constitutional functions of legislating or performing oversight, then it should be entitled to that information. In the law enforcement context, it requires a showing of a legitimate legislative purpose. And then finally, any credible evidence that arises of unlawful activity within the executive branch, the statute would then entitle Congress to information about that particular subject matter. And then the last element of the statute is that it expressly authorizes Congress to submit executive privilege disputes to the courts for expedited resolution. Many people sort of instinctively balk at that particular element. So there's a couple aspects of it that I want to point out at the outset, and that is Congress would not be allowed to go to the courts for judicial determination on the issue until negotiations between the branches had been exhausted and had not been able to resolve the conflict. And also, a majority of either the House or the Senate would have to vote to authorize the suit. So we think that under this framework, the vast majority of disputes when they arise would continue to be resolved through the traditional process of negotiation as it has been done for over 200 years, but that the existence of a judicial remedy sort of at the end of the tunnel, if it was necessary, would provide a little extra incentive to the parties to maybe let go of a bit of their stubbornness when that was necessary, and I think there have been some historical examples that show that that is actually the case. So those are the basics of the proposal. To be sure, it won't fix all problems. As our speakers have already said, Congress still will need to exercise the will to pursue information that it needs. The executive likely will continue to resist disclosure, even when maybe they shouldn't. But we do think that this statute provides Congress with another tool that it could use to ensure that it has the information it needs to legislate wisely and to effectively perform its oversight function.
Okay, so really would love, not questions are fine, but dialogue's fine too.